Okay. No questions or anything? Again, thank you all for joining. I respect your time, so we're going to jump right in. And if others are coming, they can just jump on and catch up. All right, let me share my screen here. Okay, so as mentioned, we will be discussing contracts and addenda. So we're going to look at the offer to purchase specifically, and I have an example a sample of how to complete the offer to purchase and contract, and things we need to pay close attention to as we are completing those for our clients, and especially if we're a listing agent, what we should be looking for on that offer to purchase, okay? We'll look at some standard addenda, although I won't go through standard addenda. We will, I will just name some that we may see today that's a little common in today's market. But we will look at the Taylor Law Office drafted addendum that that they created specifically for our market center. So we'll take a look at that. All right, so when we're looking at the offer to purchase, one thing I want to note, if you are representing a buyer, you're a buyer's agent in a transaction, the buyer agency agreement, of course, must be in writing prior to writing the offer to purchase. So make sure that's in writing. I know you all know this, but it's just a good review. So buyer agency agreements must be reduced to writing prior to writing an offer. There are some standard contracts, you know, there's a standard offer to purchase, the 2T, then there's one for vacant lot and land, and new construction. All right, but we are going to look at the standard addendum. I'm sorry, not standard addendum, standard offer to purchase first. So let me stop sharing here and bring up the standard offer to purchase, and let's go through that. There we go. All right, let's get it up on the screen. There we go. All right. Can everyone see this one? You should be able to see it on the screen. Yes, okay, very good. All right. So let's look at it. Always remember in the very bottom corner, let me just scroll to it. We want to make sure we are using the most up-to-date form. The ones that come out July, if there are any changes, they come out every July of the year. So we just had an update to this one, to the offer to purchase, and other forms created by the Association of Realtors. So make sure we're using the most recent form. We are supposed to or required to use them September 1st of every year. So we should be using this one. These forms are required now. All right, looking at the offer to purchase. Paragraph 1, terms and conditions. Of course, we will complete and fill in the seller's name there, as well as the buyer's name, and make sure that we are including all sellers and all buyers. So if it's more than one, make sure we list them all. If there are more buyers, or especially sellers and buyers, than can fit on the offer to purchase, there is a form for additional signatures. So there's an addendum that addresses additional signatures specifically. Okay. 1C. Yes.
A quick question about that. If you have more people, do they have to initial each page?
I don't believe they have. Just a good question. I don't believe they have to initial, but you know what? I'm going to verify that. I just know that that addendum controls. So most times the addendum will control. So that's a very good question. I don't believe they do. I believe it's just if they sign that additional signatures, then we should be okay. But that's a good question, April. I'm going to write that down and I'm going to verify that. Okay, good question. We will get to that and we'll have an answer for you tomorrow if I don't find it or get it shortly after boot camp. All right, great question. Okay, moving on to 1C, property description. So we want to be as specific as we possibly can here. We want to make sure not only do we include the address and make sure, I will say this, we need the, not the mailing address. And there's a note here in that second blue note box that we see, or the blue box. It says governmental authority over taxes, zoning, school districts, utilities, and mail delivery may differ from address shown. So we want to make sure we are using the correct address. There have been instances where the correct address wasn't used or they thought it was the address. However, the mailing address was different, county address was different, and they ended up contracting the wrong property. So make sure that we are using the correct address, which is why the additional legal description below that box is here. To make sure we're looking at the correct deed, we put in the deed book, deed page, and the plat book, plat slide or page specific to the address and property that's being contracted. So make sure we're looking that up on the county records. All right, 1D, we're still talking about the terms of this offer. Of course, we're going to put in the purchase price. Then next line is due diligence, and we are seeing due diligence in the 5 figures in this market. So we're going to put in that due diligence there. One thing that has changed on this one, as you all may have noticed, I'm pretty sure you noticed already, is that now we can be specific as to how the due diligence is going to be paid. So remember, due diligence is due the effective date of the contract. So once this becomes a contract, all parties have signed and agreed to the terms. There's no counter offers involved. Once it's a contract, due diligence is due and payable. So now we can specify if it's going to be by cash, personal check, official bank check, wire transfer, or some type of electronic means. And that can happen. And for this example, we just put in here electronic transfer through Cash App. It could be Venmo. It could be some other type of electronic means. However, regardless, now here's the thing, let me say this. The seller and buyer have to be agreeable, mutually agree to the electronic transfer. So a buyer can't just can't say, well, I want it by Cash App, but the seller doesn't agree to that. So make sure it's something that both parties are agreeable to. Now, what do we do when it's an electronic transfer and it's not, we can't snap a copy of a check? What do we do in that case? Suppose it is Cash App. Buyer says, I'll Cash App it, give me your Cash App name or ID or whatever, and seller says, great, I have Cash App, don't mind doing that. And they hand it over, buyer sends it, seller receives it, shows up in the bank account. What do we do? Because we don't have a picture of anything, right? Well, and we never receive it. So we can acknowledge as a listing agent that we received it. So best thing to do is have the buyer either print it seller print it, screenshot, take a photo of it or something to give us proof that it's been sent and received. So some type of proof, we still need that proof, even though we can't snap a photo of a check. So that's imperative. All right, moving on to the next line, which is initial earnest money. This portion hasn't changed. We still have to specify how the earnest money deposit will be paid: cash, check, bank check, wire transfer, electronic transfer. We have a choice, or the buyer has a choice, either paid by the effective date of the contract or within 5 days of the contract. So whichever suits the buyer and seller, of course, and seller agrees to, we need to notate that. Same thing with that initial earnest money deposit. However it's given, we need to get proof of that because that's something we need to include in our command compliance files as well. So as long as we have proof that it's been sent and or received. Okay. For this particular example, there's no additional earnest money given, so nothing there. However, that is a time is of the essence date, the one of two in our offer to purchase and contract. So of course, when it's due by 5 p.m. on that particular date, whatever that date is. All right. And of course, we can check how it's going to be paid. Next one is by assumption. I haven't seen assumptions in years. Of course, it's an option if both parties agree. Seller financing, that's an option. Again, if both parties agree. If it is seller financing, make sure there's a seller financing addendum attached, or there's something from the buyer's attorney stating how the seller financing would work. Next to the last line is building deposit. If this is new construction, then a building deposit may be appropriate. Very last line, once we add up all of the previous lines from purchase price, subtract out of it all of those ways it's going to be paid, then at the very bottom, the balance of the purchase price will be due in cash at closing. Okay. All right. Okay. I want to notate and point out on the second page, the top paragraph. Should the buyer fail to deliver the due diligence or initial earnest money by their due dates, or should any check or other funds paid by the buyer be dishonored by their institution for any reason, buyer shall have 1 banking day after written notice to deliver cash, official bank check, wire transfer, or electronic transfer to the payee. Please note that it says buyers shall have 1 banking day after written notice to deliver. All of these options are immediately available funds. You notice there is no personal check there. Okay. 1 banking day to deliver immediately available funds. Okay. Not personal check. So in the event buyer does not timely deliver the required funds, of course, the seller shall have the right to terminate the contract upon written notice to the buyer, and the seller shall be entitled to recover the due diligence fee together with all earnest money deposit paid or to be paid in the future. That is the seller's remedy for a buyer breach of the contract as it relates to not delivering funds. In addition to this, the seller may be entitled to recover reasonable attorney fees and court costs. And it will explain it more in paragraph 23 following. Okay. So make sure as buyer's agents, we are educating our buyers properly. There could be repercussions if they are not delivered. 1E defines earnest money and how it should be deposited. Of course, earnest money should be deposited in a trust account, which our office, our market center does not have. So we do not have a trust account. Therefore, the buyer needs to either give earnest money deposits to their closing attorney, or if the listing firm has a trust account, that's an option as well, which we see in section 1F. The escrow agent needs to be identified in 1F. Okay. The blue note here in the blue box talks about and explains if there's a dispute between the seller and the buyer over how the earnest money deposit that's held in the trust account will be dispersed. It tells and explains what will happen to that earnest money deposit. So it says here, a licensed real estate broker, if they are the escrow agent, is required by state law to retain the earnest money deposit in the escrow agent's trust account or escrow account until the escrow agent has obtained a written release from the parties consenting to the money's disposition, or until disbursement is ordered by a court of competent jurisdiction. So if there's a dispute and both parties have not agreed, then the escrow agent has to hold that money in their account. It's a certain time frame they can hold it. After a certain time frame, if the seller and buyer have not agreed, then the attorney has to notify them, or should notify them, and let them know it's going to be deposited with the courts. It's interesting. I had that happen. I want to say just last year, back in 2019, one of my buyers, an investor, paid earnest money deposit to the seller, and the buyer did not purchase the property and asked for the earnest money back because the seller did not disclose that the HOA would not allow one of the properties to be sold as an investment property. And the HOA didn't have enough in their expense accounts to cover the things that the lender needed. So the buyer couldn't buy because the lender wouldn't lend money, the funds. And so the buyer says, well, seller, it's your fault. You should have known that. Your listing agent should have found that out before listing. I want my earnest money back. Seller said no. Well, there was no agreement, so the attorney could not release it. Well, after a period of time, which was last year, this happened in 2019, the attorney reaches out to me and said, hey, I got to get this out of my account. I have to turn it over to the courts. I'm going to give you all one last time to see if you can agree. And it ended up that finally the seller said, you know what, it's not even worth fighting, so let me just give it back. So my buyer ended up getting it back. They finally agreed and had to end up signing the mutual agreement. So that could have, in my opinion, could have been done almost the year prior to that. But anyway, the attorney cannot, or the escrow agent cannot release unless there's mutual agreement. Otherwise, he has to turn it over to the courts. All right, 1G explains and defines the effective date, what that means. I won't go through that specifically. 1H defines what is meant by due diligence, which of course is the buyer's opportunity to investigate the property. 1I defines due diligence fee and when due diligence starts and the parameters surrounding the due diligence fee. Make sure we are familiar with these so we can properly explain these terms to our clients, okay? 1J speaks to the due diligence period. And of course, due diligence begins the effective date of the contract through a specific date that's agreed upon between the buyer and the seller. This should be, it needs to be a specific date. It should not be 10 days from effective date of contract or 21 days. It needs to be a specific date because this is a time is of the essence date. So we actually need a date in there. Now, I will say, as a buyer's agent, if you're completing this for your buyer and in the beginning, you want to start with 10 days from effective date or 21 days, that's fine. But before or by the time it becomes a contract, it needs to be changed to a specific date. The same with 1L settlement date. That should be a specific date. Okay, 1K defines what settlement means. And of course, settlement is signatures, meaning the signing of all of the documents necessary for closing. Yes.
About the specific date.
Yes.
Also, in this market, sometimes they call for offers on a certain day.
Yeah.
Well, you're writing it in the first day, and it's going to be 5 days from now before someone reviews the offers.
Right.
And you put in, and I've seen it, people would put in there 20 days past the date of execution.
Mm-hmm.
Of the document. Is that acceptable?
It should, it's okay. However, it should be at some point translated to a specific date. So it's fine in the beginning, but at some point it should be specific because, and we'll see it later, computation of days and how to actually count days. So to dispel all confusion, it should at some point be converted to a specific date.
And I've seen it that way specifically when, you do have multiple officers, they've called for it.
Yeah.
And also have multiple people that have to sign that aren't all physically in the same space.
Mm-hmm.
So past the date of execution could be 20, I had one, it was 11 days past the time we submitted the offer
Right.
for the person.
Right.
So if it were that and you only had a 14-day due diligence period in there, well, most of it's gone.
Right, exactly. Yeah, so and I believe that's so many days pass, which and I it happens all the time because we put them in there all the time. At some point, it should be because so that we're all on the same page, and especially when the attorney receives it, so we can get that date specific on the calendar. Yeah.
Okay, thanks.
Yep. Yes, ma'am. Good questions. Good questions. All right. Okay, next page. All right. 1M defines closing and what is meant by closing. It's the actual legal process at this point. Settlement has occurred, meaning documents have been signed. Now it needs to be recorded. Funds need to be verified by the attorney. And at that point, funds can be dispersed once it's been recorded. Funds can be dispersed and keys can be given. All right. There's a red warning box. Blue boxes are notes, red boxes are warnings. The warning here is that in North Carolina, we are an attorney closing state. So all documents have to be prepared by an attorney, okay, for closing. 1N defines special assessments. And later on, we'll see who is responsible for proposed and confirmed assessments. And we see that here in the blue box, in the note box, and it says buyers and sellers, respective responsibilities for the payment of special assessments are addressed in 6A for buyers, I believe, and 8K for sellers. All right. Moving on to paragraph 2, fixtures and exclusions. I like this warning here, and it says the party should not assume that an item will or will not be included in the sale based on an oral or written statement or understanding that is not a part of this contract. So if the buyer wants it, they need to spell it out in the contract. And they should be very specific when negotiating. I tell you, fixtures and things can be a big deal. So moving on to 2B, specified items. Here, the North Carolina Association of Realtors and the Bar Association has taken it upon themselves to go ahead and predetermine and identify what items are definitely considered to be fixtures, meaning they remain with the property based on their method of adaptation, okay? Based on the intent of the attacher, whoever attached it. So this list was not existent when I started in real estate. There was no list of fixtures. This has grown over the years. And remember, I want to make a note here. It says all items listed below include both traditional and smart versions, and any exclusively dedicated related equipment or remote control devices that go along with it. So if there's a garage door opener, it's a fixture, automatic garage door opener. Well, the remotes should remain with it as well, just as an example. I won't go through this entire list, but make sure if it's important to your buyer and the buyer wants it and expects it at closing. I will say, because I've had buyers who were burned, even though it was listed in this fixture list, we didn't include it. We didn't think it was necessary. However, the seller was removing the fixture prior to the property closing. The day before it closed, seller had someone there taking down these items and removing it. We didn't think it was necessary to list it. So I will say, as a best practice, if it's important to your buyer and it is listed, still write it in the space provided. All right, 2C is a caution to the sellers, making sure they unpair their smart devices and electronic devices in the property. Clear out all of the seller's data on those devices. Okay. 2E, if items are not owned or will not convey, these need to be specified. The seller, number one, and listing agent need to make it known. That's number one. Number two, they need to make sure it's included in the items that will not convey. And as an example here, we just have the security system wouldn't convey because it's not owned. And in 2E, for this example, the chandelier in the dining room. Maybe maybe the seller didn't have the opportunity to remove it prior to it being shown. And so we just need to make it known that it will not convey. All right. Also, please let sellers know that if they remove a property or piece of personal property, they need to, or remove a fixture, the seller needs to repair any damage that was caused by the removal, okay? I had sellers to remove their ring device and security system and left the damage. So they didn't tell me it wasn't going to be included. So make sure we educate our sellers as well. All right, paragraph 3, personal property. If there's going to be personal property included with the transfer at no value, this is where we include it and notate it. I've seen a lot of items written here. Refrigerator, washer and dryer, patio furniture, the TV in the dining room or living room, and all of these items. Make sure as a buyer's agent that it is okay with your buyer's lender that all of those items be included here. If the buyer is obtaining a loan, those items may start to add up, and the lender may request that they be removed from the offer to purchase and handled separately through a bill of sale. Big ticket items specifically should not be included here. Things like a boat, or there was one, it was had a buyer who wanted to purchase a property that had a garage, a detached garage, and they had a lift, a car lift installed, and that car lift was expensive, and that had to be handled separately. All right. The note advises the buyer that if any personal property will be included and should be a part of the sale should be identified in the paragraph above. Okay. Paragraph 4, the buyer's due diligence process. All right. So here's a warning, and the warning is to the buyer, letting the buyer know that they are strongly encouraged to conduct due diligence during the due diligence period. Make sure it's done during that time. If it's not completed before the due diligence date, then the buyer, of course, can request an extension. However, as stated here, the seller is not obligated to grant it. Okay. These warning boxes are definitely good to make sure we point out to our clients. All right. Continuing with paragraph 4. All right. The due diligence process for A discusses the loan, if the buyer will be obtaining a loan. For B discusses or addresses the property investigation, inspections, document review, HOA, restrictive covenants. Those are examples. Buyer needs to make sure they obtain their insurance, get a survey if they so choose, check in zoning and governmental regulations, making sure they can do with the property what they want to do with the property, making sure there's no surprise zoning changes coming in the future. Flood hazard, if it's in a flood zone, or if it needs to find out if it's in a flood zone, they may need to obtain flood insurance. All utilities and access, easements and things of that nature, making sure the utilities are available. Streets and roads, especially if it's a private road, making sure or checking to see if there's a private road maintenance agreement. Any special assessments, and if there's a fuel tank on the property, we need to find out all of these things. Now, that it's not all, this list is not all inclusive of everything a buyer may need to check. It may be important to them to do a radon inspection. So whatever the buyer wants to do or needs to do needs to be done within that period. All right, sale and lease of existing property. It speaks to that here in 4C. 4D, repair improvement negotiations and agreement. If the buyer is going to request repair, that needs to be done during that due diligence period. I will like to notate the very first sentence of 4D, and it says, buyer acknowledges and understands that unless the parties agree otherwise, the property is being sold in its current condition. Make sure buyers are aware of that. Okay. Continuing on with this due diligence process, 4E speaks to the buyer's obligation to repair damage if the property is damaged as a result of the buyer's investigation. 1F is indemnity, that the buyer will indemnify and hold the seller harmless from any loss or damage claims or suits which arise out of anything that the buyer does during their investigation period, and even the agents or contractors that the buyer may have during this due diligence period. 4G speaks to the buyer's right to terminate. So provided that buyer has delivered and agreed, has delivered any agreed upon due diligence fee, buyer should have the right to terminate this contract for any reason or no reason by delivering to seller a written notice of termination. All right. And it speaks to that the due diligence period is a time being of the essence date. So the buyer needs to make sure they do it on that date before 5 p.m. All right. 4H says that closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. That's the big one. I'm getting some situations from listing agents where a buyer bought the property, something happened, there was no repair agreement or anything like that. Buyer wasn't satisfied with something, or they said something was different by the time it was sold. And when it closed, now the buyers want, well, the seller didn't do this or the seller didn't do that. But the thing is, it's closed now. And once it's closed, it states here in the contract, it constitutes acceptance of the property. So as buyer's agents, make sure walkthroughs are done, and please have your buyers notate anything that needs to be taken care of prior to it closing. Okay, moving on to paragraph 5, buyer's representation. So here, very first one, 5A, speaks to how the buyer is going to purchase the property. I actually like how they changed this. I love this. Seems like it should have been done a long time ago, but I guess the market that we've been in has caused a lot of changes and clarifications to our forms. Love this. 5A speaks to the funds to complete the purchase. First box is if the buyer is paying cash. I love that it's a separate section. Love that. So if buyer's paying cash, they would check that box, of course. And I like that it has here, the very last sentence of 5A says the verification of cash available for settlement is or is not attached. Love that. There's a note to sellers here in the blue box. If the buyer isn't obtaining a loan, it cautions the seller and the seller is advised that before you sign the offer, obtain some documentation from that buyer to demonstrate that they can close on the property and have funds for it. So definitely do that.
So Teresa, I have a question.
Yes, ma'am.
So for the cash verification, so on a townhome that I had listed a couple weeks ago, that one I received 2 investment offers on, and both of them sent me a screenshot of their bank accounts.
Okay.
Is that common practice? And is that what would equate to the verification of the cash funds?
Yeah, that's a good question, Lauren. I guess we're in an electronic technology society, so that could be acceptable, but that's going to be up to your seller. That's going to be up to the seller if they are comfortable. And of course, as a listing agent, if you're comfortable and how you would advise your client, is that sufficient? It very well could be, but I may ask some questions. thank you for the screenshot. Is there some way you can print that or, and provide it? So that's a very good question.
Is there a way, like, would you ask the bank to create a formal letter for it? Like they have funds in excess or the funds capable, kind of like a pre-approval, but for cash?
Yep, I've seen it done. That
Okay.
is a valid and fair question. Absolutely. I've seen banks do it. Yep. And people with investment portfolios that, like a JP Morgan or what's that other one? Row something, TD Row, whatever. They had investment accounts. Yeah. And they had them write a letter stating that they had the funds. So yes, that counts as well. Absolutely.
I've received like complete bank statements.
Yep.
I would encourage anybody that's going to submit that to block out account numbers.
That's right. Exactly. That's exactly right, Eric. Ethiel, I tell you, we just got one on one of our listings and they included the entire bank statement, but on each page or something, they blacked out the account numbers and all of that. So yes, that's a good one. Make sure you do that. Make sure they do that. Sorry, just 1 second. Okay. All right. Yeah, I love how they did this. They separated it out. Absolutely love that. So now 5A, the second section of 5A says if they're not paying cash, the or is they're getting a loan. Like how they've separated this out. And it's if they're obtaining a loan, and in this example, the buyer is obtaining a loan. And it says, let me just read this here because I like the language of it. It says loans or other funds. Buyer intends to obtain a loan and or other funds to purchase the property from the following sources. And it states that the buyer should check all applicable sources. The word here is that I like and that we need to pay close attention to is intends to obtain. Not saying they must obtain or they are required to obtain. However, the buyer at this point, at the time of the offer, intends to obtain. Buyers I've seen in this market change their mind. So just wanted to point that out. The verbiage here says buyer intends at the time of this offer. All right. In this example, again, they're obtaining a loan. They will be getting a first mortgage loan, and there are the details on that. We see here that in this example, they are obtaining an FHA loan, which means they need to attach the FHA addendum with it, okay? Whichever applies, that's what we need to check. Of course, the amount that they will be obtaining a loan for goes in that blank. The other portion that I like here is that they've broken out a second mortgage. And a lot of times, if a buyer is obtaining a loan using down payment assistance funds, that can be a second loan against the property. So that box may need to be checked in that specific instance if they're obtaining maybe a down payment assistance or something to that effect. And the last box notates other funds if the buyer intends to obtain funds from other sources. If they are, then they would include that there. Okay. All right. The note here in 5A states that the buyer's obligations under this contract are not conditioned upon any loans or other funds from sources other than buyer's own assets. It also says that some mortgage loan programs and other programs providing funds for the purchase of property selected by buyer may impose repair obligations and or additional conditions or costs upon the seller or buyer, and more information may be needed. So I like that they put this note here. I like that as a kind of caution to the buyer and the seller. And it goes on to say that material changes with respect to funding the purchase of the property that affect the terms of the contract are material facts that must be disclosed. So that says if the buyer is obtaining a loan and can't get that particular loan and they need to change their loan product or something, or the type of loan, that needs to be disclosed. Okay. All right. See a note here in the chat. So let me read it here. So if they were putting down a chunk of cash and getting a loan for the rest, would you check cash and put in that amount and then do the rest in the loan area? Yeah, you could definitely do that. Absolutely. Absolutely. That way you're letting them know, or the way to do that would be, let me go back up. Just putting, if they are obtaining a loan of any amount, you could just notate the loan box, check the loan box, as well as once you check the loan box, just put in there the amount they're getting the loan for. So for instance, in this case, I think the property was 425 or 450. Say if they were going to put down 300,000 in cash, and their loan amount would only need to be 150,000. So that's the amount you would just put in that financed section there. Very good. Good question. Did that help? Hopefully it did. Yeah, okay, perfect, perfect, perfect. Great question. All right, moving on to 5B, other property. Here is where the buyer needs to notate whether or not they have another property to sell before they can purchase this property. So buyer, in this case, buyer does not have to sell another property before completing the purchase of this property. If they did, they would check the box. If they did have to sell, they would check this next box to determine whether it's under contract already or not, or the last box that says the buyer's other property is not under contract. And if it's not, they need to notate what the status is. If it's currently listed and actively marketed, or if it will be listed, or if the buyer is attempting to sell it themselves. Now, even with the buyer disclosing this information, the note box says that this contract is not conditioned upon the sale or lease or closing of buyer's other property. If the parties agree to make this contract condition on a sale or lease or closing of the buyer's property, then they need to have an addendum created and drafted by an attorney. So we no longer have a contingent sale addendum. That went away in 2019. So if it needs to be conditioned upon it, then the buyer needs to go see an attorney and have that drafted. All right. 5D speaks to the property disclosures, whether or not the buyer has received the disclosures or not, and they can notate which one it is. If the buyer has not received disclosures, then there can be some repercussions on the seller's side, because if it's not received, or if they don't have it by the time they make this offer, and that it goes on a contract, then the buyer can void or cancel, terminate the contract. It then becomes a voidable contract because the buyer can terminate. Okay. All right. The note in paragraph 5 speaks to the parties are advised to consult with an attorney prior to signing this contract if severance of mineral, oil, and gas rights have occurred. So if that is the case, then have your client seek an attorney and get some advice there. I've had that happen. I was the buyer's agent. The property was built by D.R. Horton, and D.R. Horton retained the mineral oil and gas rights to the property. The seller wasn't aware. So when my buyer went to purchase, attorney did the title search, saw that the mineral oil and gas rights were not included. The buyer at that point had to determine whether or not they wanted to continue. However, my buyer said, I want the house, but I want everything that's supposed to come with it. So the seller ended up having to contact D.R. Horton's headquarters and request that they give back the mineral oil and gas rights. And D.R. Horton did. They gave them back. It delayed closing. Closing took a little longer because they had to be given back, recorded, and show up. So they did do right and give the mineral oil and gas rights back. Buyer ended up buying the property with all rights intact. If they are making, I'm just reading the question in chat here. It says, if they are making it contingent on the sale of their house, the buyer needs a lawyer to draft that. That is correct. Yes. All right. Moving on to paragraph 6, buyer's obligations. I won't go through all of this, but buyer's obligations, they are responsible for certain costs, okay? That's 6B. 6A says that the buyer is responsible and shall take title subject to all special assessments that may be approved following assessment. So as it relates to pending assessments, they are not confirmed, then the buyer, when they take title and purchase this property, they are responsible for any assessments that come after closing. All right, 6C, buyers obligated to disclose certain information that's necessary to complete this transaction. And that brings us to paragraph 7, seller's representations. Seller needs to notate how long they've had ownership of the property, or if they even have ownership of the property yet. 7B says they need to notate if the property was built prior to 1978, there must be a lead-based paint disclosure completed by the seller. 7C speaks to the HOA or owners association and dues. They need to disclose whether or not HOA is applicable and what that amount is, if any. All right, paragraph 8, seller's obligations. I won't go through or read any of this here, but please be familiar with this. 8A is evidence of title. And again, they need to convey the title, or should be able to convey the title by a general warranty deed. 8B, authorization to disclose information necessary to complete the transaction. And the seller needs to allow access to the property, okay? Buyer needs to conduct their investigations. 8D speaks to the removal of seller's property. Please know and instruct your sellers, please get all of their personal possessions off the property. All garbage and debris must be removed from the property. That is the seller's responsibility. 8E, affidavit and indemnification agreement. Seller needs to furnish that at settlement. Of course, the attorney is going to make sure that that is provided. And 8F is if there are any liens as notated by North Carolina General Statute 44A 11.1, they need to notate that if there's a lien agent, or if there's a mortgage and any liens on the property, that needs to be dealt with and taken care of, and the attorney does that, of course. 8G, good title, legal access. Again, if this standard form is used, the seller has to deliver a general warranty deed for the property to the buyer. Okay. All right. Make sure we are aware of the notes here. Buyer's failure to conduct a survey or examine title of the property prior to the expiration of the due diligence period does not relieve the seller of their obligation to deliver good title. Okay, so that is the seller's responsibility, regardless of the due diligence period expiration. The second box speaks to short sale. If it's a short sale, there needs to be a short sale addendum attached. Okay. 8H. 8H. Wow, I can't say that 5 times fast. Speaks to deed, taxes, and fees. Of course, this is where we're going to put the buyer's name and how the deed should be made, or who the deed should be made out to. And in this case, it's John Doe or Jane Doe, and they are married. Okay. 8I is where we would include if the buyer is asking for any closing expenses. This is where that would go. And I've seen 0 so many times in this market. I don't even know, are buyers asking for closing expenses in this market? I haven't seen any.
Yes, I actually had a contract on the townhome that I got under contract last week come in. She was requesting $3,000 in closing assistance, but
Okay.
I said, well, she, you know, it was a VA, it was a FHA, and I talked to the broker and I was like, well, this also qualifies for USDA. And he was like, oh, let me check with her lender. And so they were able to switch her to USDA, so she didn't require the closing assistance.
Nice. Look at
Mhm.
you, been an
Whoop, whoop.
astute listing agent. Love it, Laura.
Yeah. Hey,
Love
I wanted her, they wanted her to get the house. This came up after we got under contract. So we wanted to make sure we had all the paperwork done and ready to go.
I love it. Love it. Love it. Love it. Love that. So, and so you were doing your job. You had a job to sell, and you're making sure it gets done, and it's a win for everybody. Love that. Love it. Love it. Ethiel, were you about to share?
Well, that was, you know, sometimes you have to work with, I mean, well, always you have to work with the other agent, and our goal is to achieve our client's goal. So we do that by working together, not against each other.
I love it. Absolutely. And that's the thing. We, regardless of the firm, you know, whether it's in the same firm or not, the common goal is to get the property sold. I don't know why that's so hard to fathom for some folks. You know, we're not the enemy. We shouldn't be the enemy. We all have a common goal.
I think of it as my goal is whatever my client's goal is. And if their goal is to sell it, that is my goal. And whatever I have to do within the confines of the law to make that happen, that's what I will do.
I love it. Love it. Love it. Love it. So Ethiel, if you can spread that out, you know, be an agent of change. I love it. Love it. Love it.
Yeah.
Thank you for sharing. Thank you both for sharing. All right. 8J, Owners Association fees and charges. I won't go through that. 8K, payment of special assessments. If the assessments are already confirmed, then it's the responsibility of the seller to take care of that. Late listing penalties, that's as relates to taxes on some property that the seller may have. 8M, negotiated repairs and improvements. they should be done and made in a good and workmanlike manner, and buyer shall have the right to verify the same prior to settlement. So negotiated repairs need to be done. That is the seller's responsibility. All right. Paragraph 9 speaks to prorations and adjustments. It just speaks to the items that are prorated at closing, which are taxes on real property, personal property, if any, rents, and HOA dues are prorated. Paragraph 10, home warranty. If there's going to be one included, then it needs to be notated, or even if there's not one included, that needs to be notated in that section. Paragraph 11 speaks to risk of loss and the condition of property at closing. If something happens to the property, maybe there's a fire or some type of natural disaster and the property is affected, it can be, the contract then turns voidable. The buyer doesn't have to terminate. It's up to the buyer whether or not they want to continue. The buyer can still purchase and receive the seller's insurance proceed at closing. So that paragraph speaks to that. Paragraph 12, delay in settlement. It has been changed. It used to be 14 days, but now it's 7 days. So make sure we are aware of that. 7 days delay in settlement. Paragraph 13, possession. We need to notate when possession will take place if it's not at the time of closing. If the buyer wants to possess before closing, if the seller needs to possess after closing, or if the property has tenants and possession is subject to the rights of the tenant, we need to notate that. Seeing a lot of that lately, not the tenants so much, but the possessions either before or after closing. Seeing that a lot in this market. That's the case, make sure we have the proper addendum attached. Okay. 14 speaks to any addenda. So we are to notate here and check the box if any of these addenda apply. For this particular example, it was an FHA loan, so the FHA addendum box is checked. If there are any other addenda, then we need to notate that. We can see that second box speaks to the additional signatures that we spoke about earlier. Also, additional provisions, that may be something, maybe the buyer wants a time limit to their offer. They want their offer to expire, then the additional provisions addendum can be used for offer expiration, as an example. Now, this next, that last box in the addenda section says or speaks to identifying other attorney or party drafted addenda. If that is the case, if an attorney has drafted something, this is where we would notate that and list out what it is. You also notice that it says party drafted addenda. If the seller and the buyer so choose to draft something and attach it to this offer, they can do so. We can't, but they can, of course, and it could be notated here.
So let me ask a question.
Okay.
The FHA and VA financing addendum, let's say you have an offer that's, it was conventional and that's what they intended to use.
Okay.
Or based on circumstances, an FHA loan, it's going to be a better fit for terms of the client.
Okay.
What do you do about it was not FHA in the beginning, but now they're going to need an FHA VA financing addendum?
Yep, I've had it happen just this year. Had that happen. So one thing, it was originally conventional, and I'll just give you just a little background on why it changed to FHA. The buyer was well qualified buyer. They had funds, funds to purchase, excess funds, they had saved up and didn't have to sell their current home to purchase. However, they were going to sell their current property and they had a USDA loan. Well, one thing I didn't know is that they had, and they didn't know either, that they had to pay back the subsidy for that USDA loan. So that dramatically reduced the proceeds that they were going to get to, not that they needed the down payment, but they were going to put money down. So, and which is why they were going conventional. But because of that, because it was going to reduce their proceeds at closing, their lender says the better loan for their situation is now FHA. So we made that known to the seller. Seller wasn't happy because they said, well, we accept it based on conventional. And that's what we thought. And that's what we thought as well. They had no idea. And it took forever for their other property to sell too. It took a while because of this subsidy, and USDA just takes forever. Let me just say that. So we disclosed it, made it known. The seller was adamant. They said, well, we're not signing the FHA addendum. We will not sign it. And guess what? Seller didn't have to. However, they have to honor the contract that's on or should honor the contract that's on the table. So my my buyers were okay with waiting to see what their proceeds would be. Had the appraisal done. They originally had a conventional appraisal was scheduled, but we found out prior to the conventional appraisal being done. So the lender was able to change it to FHA. So, and because of that, it passed the appraisal, no issues, no worries to that. And after that, because it actually appraised over what it was under contract for. And the reason why one of the reasons why the seller didn't want to sign the addendum is because my buyers offered over list price, $10,000 over. Well, it ended up appraising over what they offered. So once the sellers knew that, the seller signed. So seller doesn't have to sign it. If it changes from conventional to FHA, seller does not have to sign. They really don't. So I think it's just in that particular situation, the buyers weren't being vindictive or wasn't being deceitful. They really were super qualified, like well qualified. Their proceeds were just reduced. And because of that, the lender, because of RESPA, the lender has to put the buyer in the best loan for their situation, or they are in trouble.
That could also be their listing agent telling them how bad an FHA loan is.
You're absolutely right.
And they're great loan products.
Yep.
I mean,
Exactly.
it's got to be the right house. Like if it's got a lot of issues, it's probably not a great FHA.
Exactly.
But if the house doesn't have any like peeling paint, handrails, those are the things that I see that, but then I had one in December of last year that I had the buyer, we made an offer FHA, and the listing agent was like, do you think there's going to be any problems? I said, probably the handrail at the back steps. I said, but we put some 2x4s up there. It won't cost the sellers anything.
Right.
And I said, if that becomes an issue, and it was not an issue.
It's not an issue.
I was like, I was expecting that and already bought some wood just in case.
You were prepared, Ethiel.
Yeah. I'm like, I don't want that, because otherwise that was the only thing that I saw. And the house was built in 1947. So that was, they're like, I don't know. I'm like, I don't think it'll have a problem. And it didn't.
And it didn't. And that's the thing. We're scaring clients, and we can as listing agents, but that's something when we go in there to do that presentation and viewing the property and walking around and looking at those things, we should be notating that type of stuff. You're right, Ethiel, and put it out there. If we see issues, even when we're listing it, that's not one we should check. We should say, okay, No, we don't know that this will pass FHA or VA. So we should be making those observations in the beginning. But
And
yeah,
it's also how solid is that FHA buyer? Did they just decide 3 days ago that they want to buy a house, or is this someone who's worked for a year and a half to save some funds, get themselves prepared? I mean, it is still possible, but they've done the prep work, and that shows in the money that they have to put down.
exactly.
Yeah, and I was gonna piggyback on what Ethiel said, and it's just about how you present the different financing options to your buyers, because they're all verified financing. They will all pay and close on the loan. You just have to know the specifics of really what they're looking for. Because there are homes that I had a Minnesota couple that they should be closing Friday. They would send me homes online, and I go, "That's not going to pass VA." And they're like, "Well, how do you know?" And I'm like, "Well, there's water stains all over the ceiling. There's a bad roof that's going to have to be replaced. Like, these are out-of-pocket expenses the VA is not going to approve." Like, and like, I knew that because I made myself aware of kind of what their biggest criteria is. And you can actually find a lot of these things online through the VA federal loan stuff. You can actually find a list of what their criteria is. And so it helps when you're working with those loans to kind of refresh yourself. So you can just kind of not steer, but like let it be known this might be a problem.
Right, exactly. And what I'm hearing from you, Lauren, and from Ethiel is educate yourself as agents. We got to educate ourselves as agents to make sure we're educating correctly and not, like you said, steer away, because we're not to do that, but just educate. And I believe I saw Tara's hand raised. Thank you for sharing, Ethiel. And
I put it in the chat directly to you, but it is illegal to refuse or convince your clients not to take a certain type of loan, correct?
Yeah, we as agents, you're right, should not be doing that. That is not our job. We are to
Okay. I'm asking because I received an odd message saying there's an agent in your area that won't take VA loans, and I didn't respond to it or anything like that, and it just got me thinking. So I just didn't know if I should even respond, but because typically it's whatever the seller wants. But I mean, is it known that some agents do practice this?
I
I don't know.
Yeah, I don't know that I know that agents are doing, making it a thing now. I haven't heard that agents are just not accepting loan types, but that's not for us to accept or reject. We follow the lawful instructions of our clients. That's what we do. So it's just our job to educate. Yeah. And
it's about education. Because I used to say, well, if you get multiple offers, if you've got an FHA or VA, just cancel them out. Truly, because that's what I was educated to understand. But the more I educated myself with complete and accurate information, I come to understand those are not bad loan products. They just have a little bit more paperwork. But it's still incredibly possible to have those great clients. And if you could miss out on a credible opportunity if you don't take FHA or VA clients.
Exactly.
I closed one last month for $520,000 for a VA loan.
Yep. And see, that's the thing. And what we really thank you all for for sharing and for your comments and questions. I'm going to tell you, it can border discriminatory practices. So we got to be very careful with how we're educating our clients and make sure that it could be construed and seen as discriminatory. So we got to be careful.
Do we have links to find, where would we find training for those types of loans?
That's a very good question. I believe we had one of our vendor partners to come in and talk about it one day. So maybe that's something we need to do again. I'm putting that on my list right now.
Didn't mean to add to your list, but I just
No.
think it's a great, I think it's just people not understanding, especially VA loans.
Yes,
And they're assuming that it's just going to be a headache and, you know, inadvertently kind of convincing their sellers the same thing.
right.
And not to, and they're trying to do the best for their sellers, but that's just still not the best.
Right.
But maybe it's just a little more education on the loans would be great. I'd love to know more information because I want to help this person out who messaged me
Right.
and say, well, I do, you know, and I'll help you. So, and just let them know it's seller.
Yeah. Yeah.
Yeah, Tim Stratton provided some brochures quite some time ago about the different
Okay.
loans.
Yep.
And I'm sure he has them in his office. Like, what is it? The VA loan, FHA, conventional, and they were like little trifold brochures. And you can, I'm sure, get them electronic, but that was a great way to provide even sellers when you're trying to educate them about what potential offers could come in.
Right.
Okay.
That's good, Ethiel. Thank you for that.
Thank you so much.
Yeah, love that. Yeah, so check out Tim Stratton. He's right downstairs. Very good. But yeah, you've just given me something else to add to the list, some things that we need to do. So I have got that on my list. All right, good discussion, good discussion. All right, continuing, paragraph 15 speaks to assignments that unless it's mutually agreed upon by both parties, the contract is not assignable or can't be assigned unless they agree. Paragraph 16 talks about the 1031 tax deferred exchange, if it's applicable. I won't go through paragraph 17, 18. Make sure we're familiar with it though. And paragraph 19, make sure we are familiar with all of these things. It's a lot of legal expressions and things that need to be contained in this offer. Won't go through 20, but again, make sure you're familiar. The one I do want to point out is paragraph 22, computation of days and times. Unless otherwise provided, for purposes of this contract, the term days shall mean consecutive calendar days, including Saturdays, Sundays, holidays, federal, state, local, or religious, okay? So for the purpose of calculating days, the count of days shall begin on the day following the day upon which an act or notice as provided in this contract was required, okay? So if the offer went under contract today, which is the 22nd, day one would be tomorrow. We would start counting on the next day. 23, I love how they changed this. Remedies. I won't go through all of them, but remedies, 23A, if there's a breach by the buyer, there are the remedies to the seller. 23B, if the seller breaches, it discusses the remedies for the buyer. 23C speaks to attorney fees. Whoever is the prevailing party, the other party, the non-prevailing party is responsible for fees and court costs and that those types of costs and fees. All right, this is where, of course, buyer and seller will sign. If it's a buyer entity or seller entity, they sign in that section. Always educate your client on wire fraud. Never take their wiring information. Do not be the middleman when it comes to wiring information. Have the attorney and communicate directly with the client and vice versa. Notice information, you can put that here if you so choose. I like here what's on the seller's notice address, notify the agent. You can do the same thing in the buyer notice address. You can instruct them to notify the agent there as well. make sure these sections, when it comes to confirmation of agency and notice addresses, make sure those are completed. Because if there's ever any issues and someone says they never received anything, we can always go back to the contract and say this is where we sent it. This, you agreed to this information, this is where we sent whatever, or this is how we contacted you. So make sure these are completed, these sections are completed. And of course, acknowledgement of receipt of monies. Please sign, have your client sign, escrow agent sign as applicable. Any final comments on offer to purchase? How it's to be completed? Best practices there. One thing I do want to show and send, because I have not, and it's a charge it to my head thing, I have not uploaded the attorney Taylor Law Addendum in Command. I have not done that yet, so that needs to go on my list too. But I do want to show it here and let you all know that it's available. Okay. Oh, thank you, Ethiel. Perfect. If you all look in the chat, Ethiel gave us the link to Tim Stratton's website for the different types of loans. Perfect. Perfect, perfect, perfect. I'm just going to copy it here. So
Kind of gives you an overview of the different loan products.
love it. Love it, love it, love it. Okay, let me snap a photo of it too so I can have that. Okay, perfect. Thank you, Ethiel, for that. Okay, real quick, just want to show the, there it is, purchase price addendum. Purchase price addendum, there we go. All right. This is the addendum that Stephen Taylor created specifically for our market center. One thing I do like about this addendum is that it is a multi-provision addendum. Typically, addenda, when an attorney drafts an addendum, it's usually a single addendum. It only has one provision in it. Sometimes it's just an appraisal addendum or an escalation clause or something. But what I like about this is that it is a multi-provision addendum. All right. Of course, we would put the property address there in the top one, seller name, buyer name. And we have the option to select which one applies to our buyer's particular or to the buyer's offer. So the first one, 1A, is the appraisal evaluation. One thing that I want to point out about this 1A appraisal evaluation is that this addendum does not override the FHA or VA addendum. Stephen Taylor could not figure out a way to override that, and we shouldn't override the FHA VA addendum. So even if the appraisal evaluation is checked and given to as a part of the offer, it cannot override the FHA VA addendum. I just want to point that out. 1B speaks to escalation of purchase price. If the buyer wants to provide or give an escalation clause stating that in the event there are multiple offers and whatever that highest offer is, your buyer may be willing to go over that amount or at least match it. they can do so with this particular clause. All right. You'll see there's a section here in bold because that says, because the listing and selling agent pursuant to the North Carolina Real Estate Commission rules to disclose another party's offer, buyer acknowledges that they will have to rely solely and only on the calculation by the listing agent of the net purchase price and cannot expect or demand to verify the net purchase price in any other way. So this is to let us know that as a buyer's agent, we should not be requesting to know another buyer's offer. And as listing agents, we should not be disclosing another buyer's offer unless we have the express permission of that offering party. Okay. All right, 1C is the as-is condition, which in my opinion, agents wanted it, so we included it. My thing is, it's a little redundant. All property based on the offer to purchase and contract that we just reviewed is sold in its as-is condition. Seller does not have to make any repairs. Buyer doesn't even have to request any. However, if it makes a buyer feel better and a seller feel better, it's there. 1C, as-is condition. The buyer will buy it as is and will not make any requests. 1D is a due diligence fee tier. This can be used when maybe it's a coming soon property and a buyer wants to make an offer on the property in the coming soon status. And so say the buyer says in the very beginning, because I haven't seen the property, I'll offer you $500 up front. However, I still want to see the property, and 2 days after I see it, or how many hours or days after I see it, I will now then give you $5,000 for a total of how many, $5,500. So that due diligence fee tier is there. This was popular when we were in the midst of COVID and no one could see property. We couldn't get in. So this became popular then. It can now be used, as I mentioned, as a making an offer in coming soon status. And please read these and become familiar with it. So in this particular multi-provision addendum, we have 4 provisions contained in one addendum. I love that. You just check the ones that apply. It goes on to give a warning that says if buyer does not terminate this contract as set out in the offer to purchase and contract, and buyer fails to timely complete settlement and closing as provided in the contract, buyer risks the loss of their earnest money deposit, which they do that anyway, but we just want to make it clear here. In the event there's a conflict between this addendum and the contract, this addendum will control, as with all other addenda. This goes on to say that this is not a North Carolina Realtor or North Carolina Bar Association form. It was drafted by Taylor Law. And here are the sections for all parties to sign. Okay. Any questions on the purchase price addendum? Of course, our agents do not have to use this particular addendum. Some agents have gone to their partner attorneys and had their attorneys to draft addenda specific to their client situations, which is totally and completely fine. We just wanted to do this as a service to the Market Center and have it available if any agents so choose to use it. All right, I believe that is, oh, one thing there is one thing I wanted to mention. Sorry about that. I just wanted to talk about other standard addenda that may accompany an offer. And those, there we go. That could be, we've already discussed FHA and VA addendum. Backup contract, that's another common addendum that we're seeing today. Homes are going under contract so quickly and so fast, but I'm seeing more buyer fallout over the last probably few weeks than I've seen in this market. Seeing more buyer fallout, and because of that, and especially in multiple offer situation, as a listing agent, you may want to have a conversation with your seller. If you receive multiple offers, is there one you'd like to ask if they'd like to be a backup offer? So that's a pretty common addendum today. Another one, of course, is lead-based paint. If it's built prior to 1978, gotta have that addendum with it. And we've already discussed the seller possession after closing and the buyer possession before closing. Those are the most common addenda that we're coming across today. Okay.
Owners Association disclosure addendum.
Yes.
For condos,
Yes.
if it's in the residential property disclosure, all of it's disclosed in there. Do you also have to fill out that owner's disclosure addendum?
Not necessarily, no. Typically that owners association disclosure is used when the residential property doesn't fit, or if the two parties choose. And I actually had that up somewhere. Where did I have that? Hang on. I'm glad you asked that.
I've never seen it either. I'm like, wonder if that's the, I've never seen it, so I'm just curious.
Yeah, where did I have that? Just a second. I put that somewhere. That was in my slides. Here it is, right here. Okay, so yeah, under the listing section, I just went back in my presentation. So when it comes to RPOs, the exclusions, here is when you would use the owners association disclosure instead of the RPOs. When it's new construction and it's never been lived in, then the owner association disclosure would come into play. Also, any type of rent to own, you wouldn't need the RPOs for a rent to own situation. However, if you needed to disclose owner association information, that's when the other one, the owner association disclosure, would come into play. And of course, it's not really necessary in a foreclosure, but if you wanted to disclose the fact, if it is foreclosed, but there's an HOA with it, then that owner association disclosure would come into play. Otherwise, it's the RPOs. That's a good one. Good question.
So what if you have, so additional signatures addendum, I think allows for 8. I have one that's come up that will have 17 signatures.
Okay.
So it's more than one additional signatures addendum. Okay. So how do you note? I mean, it's a listing, but how do you note that? Like,
yeah,
if they're gonna all sign the offer to purchase,
Mhm.
you're gonna need some extra
Mhm.
paper.
Yep, and I would probably just use multiple additional signatures. Addenda, just how many ever it is, just use multiple forms.
And maybe, I mean, I'm thinking like put in there like 2 pages.
Yep.
You know, this
Yep.
page 1 of 1, but you're gonna, it's okay.
Yeah, I would just use multiple, and so I just use 3 of those, or how many ever would cover the 17. That's a lot, Ethiel.
Yeah.
A
A whole lot of, a whole big family.
oh wow. So is this air property or estate
Yeah,
or
it's a-
okay? Gotcha. Yeah. Yeah, I would probably just use multiple or attorney drafted, but if it's going to be a cost to that, then I would just use the multiple additional signature forms.
I mean, it turns out, I mean, because several of them are married, which
Right.
makes signatures.
Right. Yeah. Yep. I would definitely do that. Yeah. That is a lot. That's a lot. All right. Very good. Any questions or comments or something we didn't cover that you want to discuss?
What if you get a form, is after September the 1st, that's on an old offer to purchase, that you receive the offer to purchase and it's using year before last form?
Yeah. Well, I tell you, I'm going to ask for a new one, because that's me. And I'm one of those rule follower people. So I would definitely ask. Thank you so much for the offer. However, did you realize its own form such and such? That would be me. Definitely, I'm going to request that it be corrected.
What if you get a great written offer to purchase, but the person filling it out failed to fill out your information? And, it is signed, or it's initialed at the bottom. How do you address that?
That doesn't have my firm information on it.
Or it's got your firm on there, but there's no firm number and your license number is wrong.
Oh, okay. Then I correct that. I actually fix it. And
Okay.
Yep, I just correct it. And that particular page, it's just more acknowledgement. It's more for the agents, that page is. It's for the clients as well, but it's more for us as confirmation. But yeah, I'm going to correct it.
Many years ago, they didn't initial that page.
Right, exactly.
It just changed.
Yeah, you just change it. And the thing of it is, one thing that in a couple of situations, attorneys have said the initials at the bottom doesn't invalidate it as long as it's signed and sealed. Not saying that they shouldn't be there, but it doesn't make the form or the information invalid. Yes, but yeah, I'm definitely going to fill it in and correct it. Yeah. All right, everybody. Well, that's day 3. You've almost made it to the end of boot camp. I will say tomorrow, I will not be in boot camp. I have some other obligations, some coaching things that I have to do. And so Tiffany will be here to cover policies and procedures. That's a big one. We need to make sure we are operating within the confines of our office rules and policies. Tara, I see your hand raised. Yes, ma'am.
Yeah, it's just a quick question. I almost forgot it. Oh, the recordings. We haven't, I don't know, is there an email been sent out? Because I haven't got an email about the recordings. So I was trying to catch up yesterday.
Okay, great question, Tara. Thanks so much for asking. That's actually going to be my fault, and I'll tell you why. Jonathan, our new tech trainer and technology guy, asked me yesterday, what did I think the best thing to do for the recordings? And here was my response. Let's get them all together and packaged up, and we would send it
Okay.
that way.
Okay. Gotcha.
So I wanted to make sure that he actually has downloaded all of them yesterday, Monday, Tuesday, he'll get today, he'll take Thursdays, he'll package, and he will send it out to everyone.
Okay, all right.
Yeah.
No biggie. I was like, I just didn't
I missed
know if I missed it.
Yeah, you didn't.
My email tends to eat things,
Right,
so.
right, exactly. So yeah, he'll package it all up once
Okay.
we're done with tomorrow's boot camp, the last boot camp.
Perfect. All right, thank you.
Very good. Thank you all. You can have some time back to your day. Make it a great one and make something happen and be the wonderful agents that you all are. Thank you for being a part of this market center.
Thanks for doing this.
All right, absolutely. Thank you all. We'll see you.